Okay, so Stuart, we talked about building this successful injury practice and how to prepare for the different type of firm and what type of practices you wanted to do. Then we discussed signing the case and the different experience that you need to have when signing the cases. We talked about dealing with the clients and the sign up and then what you had to do to begin the case. Then we talked about the important features of managing the case and the different types of systems that you needed. And then what to do to prepare to go litigate. We talked about the litigation process. Then we went into the mediation and settlement part of the conference and some other tools you can need. And we also discussed about what to do if you are an attorney and you don't have experience in personal injury and you have a big case. How do you handle that while still maintaining the client relationship? So obviously, if all else fails, now we need to go into the trial phase. So could you talk about what happens at the beginning of the trial phase, your preparation for that trial, and take us from beginning to end?
Sure, Rick. When I get a case, from day one, I start thinking about the trial of the case and how to prepare the case as if it is going to go to trial. I believe that gives me credibility with the insurance companies, and it also gives my clients a sense of confidence that I am prepared to move forward on their case regardless of what happens. In that sense, we develop a theme for the case as early as possible. We try to think about what would the average person in the community hearing this case for the first time want to know about, what would be important to them, and what would make them want to award a sum of money to our client. You have to understand that our clients live with their injuries every day. Their family members live with their injuries every day. We as attorneys working with clients for months or years get to know them. But a jury gets a very small snapshot of what has happened to this client and about their life. And it's our job to go ahead and make that snapshot into a short motion picture, so to speak, giving an overview of the client's life before, what happened to the client in the incident, and what their life has been like since the incident and what they could expect in the future. And that's an awesome responsibility. And there's lots of ways to go ahead and do that, and that's what I want to talk to you about today. In order to get ready for trial, there's many things that you need to do besides developing the theme. You need to know your case. There's no substitute for knowing your case. Because when a judge asks you a question in front of the jury, you want to be prepared to answer it. You don't want to stumble. When a juror asks a question, sometimes in some states they're allowed to. You don't want to stumble. And you also want to be able to have all your exhibits and all your facts at your fingertips so the jury feels that you are prepared and knowledgeable about this case. You're not wasting their time, and you're there to do a professional job and accomplish everything that you set out to do. You know, we live in a world of television shows where trials start and end in 1-hour segments on television. So jurors are into getting information very quickly. They're used to the internet. They're used to very short news stories. And you have to be very careful and really create a balance between presenting your case in a streamlined manner, but yet at the same time getting all the facts that you need in order to protect yourself under the law, to make sure your record is clear, to make sure you've proven all your elements, and you've covered all your area of damages. So you've really got to organize your case in such a way that you could accomplish all this and not waste the jurors' times. We create outlines. We lay out in advance what it is that we want to accomplish in a trial and what the best order of proof is. And what I mean by that is, what way do we present the evidence? Who do we put on first? Who do we put on second? What exhibits are we going to use? And these are things that need to take place months in advance of trial because it takes time to prepare them. Sometimes, depending on the size of the case, we'll hire a jury consultant. We'll go through a mock jury situation where we actually have a mini trial in front of strangers that are paid a fee to come and hear the facts of the case and deliberate. And we'll listen to these deliberations, sometimes behind a one-way mirror, sometimes in the same room. When we present these mock trials or focus groups, we present them more favorable to the other side. We want to hear how a jury is going to react when the other side, the defense, is more powerful, has more persuasive evidence, so that we know what jurors are listening to, what they're hearing, and what is important to them. And then we craft arguments and create evidence and exhibits to go ahead and counteract those arguments. Technology is important. words today don't mean everything. We use medical illustrations because if you hold up an x-ray of a fracture to show a jury, it's a black and white negative. What we do is we hire medical illustrators, or if we're using a PowerPoint presentation, to actually turn that X-ray or the MRI scan or whatever it is into colorful 2- or 3-dimensional images so that a jury can not only see the fracture but how it was reduced, if there was a reduction that was necessary with surgical screws and hardware. We bring it to life for the jury. We try to show them if the client's hurt very badly, a day in the life film. What that person goes through from the moment they wake up in the morning to the moment they go to bed at night, to see the hardships that they go through. What I tell my clients is that the human mind is a wonderful thing. We tend to learn how to adapt to changes in our physical and mental health. We tend to forget pain and horrible experiences. But a trial is a time when you've got to get your client and his family or their family and their friends to go ahead and relive those horrible moments, those horrible days, and those terrible, painful experiences so that they could properly be conveyed to a jury. This is all the preparation work that goes into trial. The depositions or examinations under oath or examinations before trial, depending on what they call it in your state, that are taken have to be outlined so that you have the information at your fingertips exactly as to what a witness said on what page. So if they changed their testimony during trial, you could impeach them using that testimony. You don't want to start flipping through pages of transcripts looking for their answers. So you want to have it outlined. What we do in big cases is we computerize it. And we could pull up, based upon a word or a question or an answer, not only the exact transcript and put it up on a screen in front of a jury, but if there's a video of the deposition, we could actually put up the video clip with the words right there. And that's a very, very powerful impeachment tool because the jury's not only hearing how the witness changed their testimony, but they're seeing the prior testimony as well. And they're seeing the demeanor of the witness. And that's also very important. Now, in our trial notebooks, we also have a lot of law. We anticipate many issues that are going to come up during the trial. And we want to be prepared to hand the court and argue to the court what the applicable law is so that we're not surprised. We'll file motions in limine before the trial, asking the judge to keep out certain bits of argument the other side may have because they're not admissible and because if they were brought out, they would be prejudicial. For example, I've had more and more cases lately where the defense lawyers ask my clients, well, when did you retain counsel in this case? That is completely, as far as I'm concerned, an improper question, an improper inquiry, and really tries to show to a jury, well, they got a lawyer 2 days or 3 days or a week after the accident, which means that they're looking to sue from day one and they're litigious, and the kind of society we're in, these are not nice people. We file motions in limine to prevent that. One of the ways we do it, too, is when I take defendants' depositions, I ask them, when did you first report this accident? When did anybody first come out to talk to you? Some states, the juries will know that there's insurance companies. Other states, they're not allowed to know. But the same that's good for the goose is good for the gander. And you'll find that the insurance companies or the defense firms don't want people to know when they got involved and how early they got involved. It goes back to that commercial from Allstate where it says the people that are injured have lawyers fighting for you. You should have a lawyer fighting for you in defense of the case. Well, it works both ways. When you're involved in, let's say, an automobile accident, the person at fault, insurance company, gets involved immediately. They're trying to take statements. They're trying to talk to witnesses, photograph the scene. Why shouldn't you, as an injured party, have the same right? So we try to keep that out of the trial because we want to try to keep the jurors focused in on the real facts of the case and not the things which don't matter as to when somebody hired a lawyer or the reasons why. Motions in limine are important because let's say your client was convicted of a misdemeanor 15 years ago. In most states, that's not admissible and has nothing to do with this case. You want to make sure in advance that the court has ruled that the defense can't bring up this conviction, that they can't talk about it because once the bell is rung, once the jury hears that, there's no instruction that the judge could give. There's no unringing the bell that works. So you need to anticipate every area of probable conflict in your case that you could try to get the court to rule on earlier. You want to rein in the defense as much as possible so that they can't ramrod you and ramrod your client by bringing in extrinsic facts during the case, which really have nothing to do with the case itself. Sorry.
So, Stuart, we've talked a lot about how you prepare the case and how you go about building up that case to go to trial. Now let's talk about a little bit about how you prepare your witness and most of all your client to be ready for the case.
The most important thing about getting ready for trial is to prepare your witnesses. And you bring up an important fact, your client. Most clients have never been to trial before. And even if they have, you certainly want them to forget anything they've ever learned before and teach them how you want them to act during a trial. What I'll do is I'll first begin by explaining the whole courtroom dynamic to my trial, who the players are, what the role of the jury is as the trier of fact, what the role of the judge is as the trier of the law, the bailiff, and everything else, and try to give them some comfort level in understanding the courtroom mechanics and setup. I'll tell them that a jury's like a play, and that I'm the director, they're the actor or actress, and that the jury is basically the critics on its opening night. And we get one shot to make an impression on the critics to get a good review. And if we don't do well in our shot, we're going to close at opening night. So it's very important that the client understand that everything that happens in a trial is really choreographed. I don't want any surprises, and if I've prepared my case, there won't be any. And I don't want my client to be surprised. So I don't want my client to understand everything that's going to happen in that case. I'll tell the client that they're on trial from the moment they wake up in the morning to the moment they go to sleep at night. And let me tell you a story that a judge told me about that. He was trying a case involving a nice mid-70-ish lady who fell and fractured her hip and was suing. He said she was a lovely woman, and there was a pretrial offer in the case in an amount that he thought was reasonable, but she refused to accept the offer. So they went to trial, and he said it was going along the first day and the second day. And, as the trial judge, he's basically just ruling on issues of law and objections. And he's getting a bad feeling from the jury in this case just by watching their body language as to how they're reacting to the plaintiff. And he's hoping that this woman will accept the offer and settle the case. Finally, the third day of trial, they come in, and the plaintiff's lawyer announced, "Your Honor, we've resolved this case." And the judge says, "Thank you," and he calls in the jury and says, "Ladies and gentlemen, I want to thank you for your service. Without you, our system of justice won't work, and the parties have resolved their differences, and your services will no longer be necessary." With that, a person on the jury says, "I hope she didn't get anything." And the second person chimes in and says, "I hope she didn't get anything either." And a third person says, "I hope they settled the case and the defendant paid her nothing." So the judge is kind of befuddled because he had given them a pretrial instruction that they're not to discuss the case amongst themselves, and they're not to really decide any issues in the case until the case is over and the lawyers have finished their summations and he's instructed them on the law. So he tells me he's curious, and he says to the first juror, "Well, ma'am, why did you say that?" So the juror tells him, "Well, the other day coming to court, I saw the plaintiff getting off of a bus. And if her hip was as bad as she says it is, my grandmother's got a bad hip. She couldn't have got down that step off that bus the way she did." And he asked the second juror, and the second juror says, "Well, we were coming back from lunch the first day of trial, and I was in the lobby, and the elevator door was closing, and the plaintiff kind of scampered around the door. And if her hip was bad, she could have never done that." And the third person related a story saying, "Well, my grandmother's got a bad hip, and I saw the plaintiff bend down to tie her shoelace during a recess, and I don't see how she could do that if her hip's as bad as she says it is, because my grandmother can't do it." So what I got from the story from the judge was that here were three people who were instructed not to consider anything outside the evidence in the courtroom and the law, who basically had decided this case upon things that they had seen the plaintiff doing in their perception of them outside the courtroom. So I tell my clients, you never know who's next to you in the next car. You never know who's watching you during a lunch break. You never know who is at a restaurant you may go to or sitting in the next booth or walking out. So you really are in trial from the moment you wake up in the morning to the moment you go to sleep at night. Jurors are going to be looking at you. They're going to want to see how you react to certain things. And you've really got to stay, I hate to use the word in character, but you do. You've got to come across as being as vested in the process as the jurors are. They're giving up their time, they're giving up their livelihood to help you, and you need to show them that you deserve their time and their investment in you. I also tell the clients it's very important to be respectful in the way they dress. I don't want somebody overdressed. I'm very careful as to what jewelry they wear, how made up they are, what type of clothing they wear. And if I'm at all concerned about it, I've taken clients shopping and actually picked out clothes for them, helped them coordinate outfits. If it's a woman, I've had a female member of my staff do it, so that they're appropriately dressed. I myself am very careful in the way I dress. I like to wear browns the first day because I think it's a warm color. I think it's a friendly color. And I want to try to not portray a corporate image with a blue pinstripe suit and a power red tie the first day, but I want the jury to feel comfortable with me when I'm talking to them in voir dire or an opening statement, which sometimes occurs during the first day of jury selection. All these things come into play. I tell my clients to stand whenever a juror comes into the courtroom, whenever a juror leaves the courtroom. When there's a juror in an elevator, try not to get into the same elevator. If you see a jury, the judge will tell the jury, and I tell my clients, nod politely, but don't speak to them because we don't want any appearance of impropriety. Please be careful of any family members or friends in the hallways and what they're talking about, because you don't want the jurors to hear something that they shouldn't be hearing or get the wrong perception. So that's an arduous task, but it's an important task. I give my clients copies of their deposition transcripts. I give them copies of their answers to interrogatories. And I ask them to reread it to make sure that their answers are consistent with the answers that they gave earlier in the case, because we don't want any inconsistencies. I make sure nothing new has happened, because if there is, I want to know about it. I want to get it out before they get to be cross-examined. And I prepare my clients. I either bring my partner in or another lawyer, and we basically role play. I ask them questions as I would on direct, and they're cross-examined, and they're cross-examined really hard. And we try to get them to look at the jury when they answer their question. Now, you and I are talking, we look at each other, because it's polite, we're taught to do that. Many people on a stand want to act the same way, so when a lawyer asks them a question, they want to look at the lawyer and answer it. But I find that if the juror or the witness looks at the jury and looks them in the eye and gives them the answer, the jury's more apt to believe that answer because they're being looked at in the eye. So I'll say, please, tell the jury. I'll try to get the client used to looking at the jury to answer them. I may shake my head a little bit to the side of the jury. I'll try to position myself in such a way in the courtroom, if it's possible, that I'm in a corner behind the jury box, so they'll have to kind of look at the jury direction when I'm asking them questions. Like a play, you have to stage it. You have to figure out where the best place is for you to stand, where the best place is for your client to look, where the best place is to display exhibits. And one of the things I like to do with my client and with other witnesses, which we'll talk about, is actually get them down out of the jury box. So if there's a picture of the scene of an accident or a car that's been damaged, I'll ask the court permission to have my client come down to hold up the photograph and show the jury a few feet from the jury box exactly what I want them to point out. I don't want them to get too close to the jury box, just like I don't want to get too close. I don't want to invade the juror's space. But at the same time, I want to try to get that personal connection between my client and that jury. My client's going to be sitting there during this trial. And that's another thing that you have to think about. Depending upon how badly your client's hurt, do you want your client there through the whole trial? Is there testimony that's going to come out during the trial that's going to be upsetting to your client, that you think would be more powerful if you asked the court permission for your client to step out of the courtroom? I had a case not long ago where I had a 17-year-old girl who had a brain injury. And there was going to be some very graphic testimony from physicians, not only about what they had found at the hospital with regard to her brain injury and the bleeding, but what her prognosis was. And I thought that as a lawyer it would be inhuman of me, and also not looked upon well by the jury, of having my client sit there and listen to this testimony as to what these doctors thought her life was going to be like in the future. And we had her step out. And we had her step out for a number of witnesses. We had her step out for her parents, because it was much easier for the parents to talk about their daughter and the problems that they saw on a daily basis with her outside the courtroom. They were more comfortable, and I didn't have to worry about the jury looking at me saying, how could you do this to a 17-year-old? I was trying to be understanding and trying to protect my client and trying to protect the jury at the same time. And it worked out very well.
So tell me a little bit about the pre-trial conference, now that you've prepared your client to witness.
Well, we also pre-trial experts. We pre-trial before and after witnesses. We don't leave anything to chance, because most people need to be told how to testify. Again, whether it's a before and after witness, whether it's an expert, we make sure that they have copies of their testimony, and we ask them to please review it. We also, if we're going to prepare for the examination or cross-examination of a defense expert, we get as much information as possible about other testimony this expert has offered. So if they deviate, we can impeach them using testimony from other cases. Even with doctors and people and engineers and people who are professionals and testify often, I go over with them how I want them to act. I want to make sure that they bring their entire chart and file with them. I think it's very impressive for a doctor who's reviewed thousands of pages of medical records in a case to come in and stack up those records on the witness stand and say, this is what I have reviewed for this particular patient. It shows that he's vested in the process, it shows that he's knowledgeable, and you want to walk him through some of it so to show the jury that he understands exactly what this patient has been through, whether it's his treatment or somebody else's treatment, or the hospital or the emergency room or the trauma center or something like that. It's a good time to use with doctors medical illustrations. Have them get down. Use models, use photographs, explain to the jury what happened. With orthopedic surgeons, I love to talk about if they do surgery. Well, doctor, explain to the jury in layman's terms, and I constantly try to remind these experts to speak to a jury on their level. Don't use big words and technical terms, and if they throw it in there, I bring them back to layman's terms. Tell the jury, what kind of tools did you use or instruments did you use to perform the surgery? And they'll talk about saws and screwdrivers and drills and wire clippers and pliers and hammers. And most jurors never think that an orthopedic surgeon is like a carpenter in a certain way. And when they hear about some young person or older person's body being subjected to drilling and screwing and titanium plates, that brings a whole new degree of understanding as to the injury. And it just creates value in your case. If it's possible to get the surgical screw, or a similar surgical screw, or surgical plate, or rod, we'll do it. And we'll pass it around. The doctor will give it to the jurors with the court's permission, and we'll pass it down that jury box. And they'll see that 3-inch screw in their hand. And you'll see in their faces how they're wincing, thinking about that's in this girl's elbow, or her shoulder, or this man's knee. It goes a long way in bringing the abstract medical testimony down to reality. And that's what you want to do with witnesses. You want to hone them in. You want to get them to be plain folk, to talk to people on their own level. You want the jury to feel like this doctor cares about this patient. You also want to get the doctor to think about all the things that could happen in the future. Now, the burden of proof for the greater weight of the evidence is just that. Nothing in science is 100%. But if you could get the doctor to testify that there's a probability that this client is likely to experience this in the future, you've got future damages. Whether it's an elbow replacement or a knee replacement, and depending on the age of your client, a series of them. And you talk about that. You talk about, well, doctor, what is it like to redo a knee replacement? You're doing one in a 40-year-old man. What's going to happen to him when he's 50 or 52 or 55? And he's going to say, well, studies have shown that the knees last 10 to 15 years, and we have to do a revision. And you say, well, tell me about the revision. Well, it's a much more difficult surgery. You've got scar tissue in there. You've already reamed out part of the femur, and you've got to go ahead and put in this new prosthetic device, and it's a more extensive surgery. Rehab's longer. The recovery's not as good, and it's more expensive. And doctor, how long is that new knee going to last? Well, it's going to last another 10 to 15 years, and they're going to need another one. So you've just gone from having one knee replacement to maybe having 2 or 3 down the road. You've gone from a $70,000 medical bill to $200,000 plus in medical bills. And you're creating damages. Not that they're not true, but you're bringing them out to the jury for them to consider. And our job is to forecast the future as much as possible. I tell jurors, this is my client's one day in court. If you don't give them enough money, they can't come back 10, 15, 20 years from now and say, hey guys, I need another surgery or I need help in my house. You didn't give me enough money. They can't do that. So the people that are coming to testify, the doctors, the vocational rehabilitation experts, the economists, they have to be able to forecast, based upon reasonable degree of medical certainty, what this client and what this patient is going to need in the future. And it's a very powerful tool. So you want the professionals to focus in on that.
Let's talk a little bit about, so you talked about the demeanor. Let's talk a little bit about dress. Obviously, that first impression is a lasting impression. So how do you address a dress code with your clients and witnesses?
Very, very, very openly. And I explain to them that I want them to be kind of neutral. In other words, I don't want their dress to offend anyone. And at the same time, if they're the type that likes to make a fashion statement, this is not the place to make it. If they have body piercings, I try to get those hidden as much as possible. Tattoos, I tried to get hidden. And it's not a personal affront to me. It's just that you never know what somebody in the jury is going to look at and like or dislike. So why give them anything to look at? If you're dressing somebody else, you've got to be careful. You don't want to go with crazy colors. You don't want to go with loud prints and ties. If it's a young person, you may want to put them in a shirt and tie and not have a jacket on them, to show their respect for the jury, but at the same time, let them understand this is a young person. Footwear is very important. If you've got somebody with a knee problem who's a lady, you don't want to wear 3 or 4 inch heels to court. That's just not a good thing, because women will tell you, well, if I had a bad knee, I couldn't walk around in high heels at all, or an ankle injury or something like that. So I make clients bring their wardrobes either to my office or I go to their house and see them. And I make them get dressed for me sometimes. And I learned that as a young lawyer, because I had a client show up one day. He was dressed in such an outrageous outfit. I asked for a recess, ran across the street to a department store and bought him a new wardrobe. Right then and there, because there was no way I could have him show up in front of that jury. And yeah, his Hawaiian shirt was really nice, but it wasn't going to play in that courthouse. So dress is really important. I make sure that they're groomed, their hair is done. If they have a scraggly beard, if they want to keep the beard, let them keep it. If they need to shave, let them shave, but that they're well groomed, that they have respect, that they're wearing socks if they're men. I mean, I love to walk around without socks, but I wouldn't do it in a courtroom. So all of that is very, very important.
And tell us, you talked about preparing the witness from the standpoint of knowledge about their case, about their interrogatories, about depositions, about the things that they've already are on the record. Tell us how you prepare the client and the witnesses for what to expect from the process of the trial.
I tell them to expect everything from being insulted, yelled at, being spoken about, and I tell them not to react. I tell them that if the other lawyer says something disparaging about them in opening, that they can't show emotion, unfortunately. They want to write me a note, they could write me a note. I don't like them to call out. I don't want faces made, because the jury's going to be watching them. And if a jury sees that our client is respectful, we have an opportunity then to put the client on the stand and explain who they are and how they act. So I tell them what to expect, how the trial is going to go, what the format is. I talk to them about voir dire. I explain to them how we're going to ask questions of the jury and to listen carefully to those questions. And when the voir dire is done, I sit and ask my jury, well, is there anybody that gives you a bad feeling? Because maybe I want to use a preemptive strike on them. I'll have members of my staff sitting in the audience during voir dire to see if they get any feeling for the people in the jury. If I don't have a jury consultant, that's even more important, to have people in the jury, in the audience, listening to what a jury is going to say.
Well, let's talk a little bit about a jury consultant, and when would you use a jury consultant, when would you not, and what are some of the benefits and what are some of the downsides in your experience?
I use a jury consultant in most cases where economically it's necessary. I have the ability to do it. In other words, if I'm trying a large, high six-figure or seven-figure or eight-figure case, I'll have a jury consultant. And that's because they're professionals. They see things and hear things that I don't see and hear. They also know how to word questions a little bit better than I do. What I try to do in voir dire is I try to get the jurors to talk. Lawyers like to talk. We like to hear ourselves talk. But that's not what voir dire is about. So you need to learn how to ask open-ended questions. And more importantly, you need to learn how to listen to the answers. And if you're asking questions, sometimes it's hard to listen and remember every nuance. So with a jury consultant there, they're listening to the nuances. They may be passing you questions. They've given you questions for follow-up. You may want to know what television shows a particular person watches. You may want to know what books they like to read, what types of books they like to read. It gives you some feel for this person, what civic organizations they're a member of. You'd like to know what part of town they live in. You're not allowed to ask their addresses, but sometimes a geographical area in and of itself will give you a clue as to where they're coming from. You want to know about their background, their education, their husband or spouses or education, their children, their parents. There's so many little things that you need to know about a jury to try to get someone to be fair. And when you're trying cases in many communities where ethnicity is involved, religion's involved, you need to know how the interplay works amongst various groups. Not that you're accusing any particular group of being prejudiced or in any way, but you need to explore all those fields in trying to pick a fair jury.
For those people who are looking into hiring jury consultants, what is the fee range generally that you've seen in the past for what a jury consultant's going to run you?
Well, everything from a inexpensive, and it's relatively inexpensive, I guess, intranet stream, where they basically send out questions on the internet and have people respond to it, which is a couple of $1,000s, all the way up through mock trials, focus groups being there during voir dire. It can run anywhere up to $20,000, $25,000. But if you're trying a 7-8 figure case, that's a small price to pay for a professional to help you, in my opinion.
Absolutely. And tell me about your process for scheduling the witnesses. Now you've kind of come into the trial, we've gone through the preparation, the jury's been picked. How do you go about scheduling your witnesses? How do you choose the order? What's your system? What's your game plan?
I try to come up with the best way to tell my story. At the same time, recognizing that certain experts have time constraints. So the first thing I'll do is I'll contact the experts and say, when are you available? When are you not available? I want to try to help and work around your schedule. And experts like that. They don't like scheduling days of surgery. If they've got to fly in, I want to make sure that they're here, in whatever city I'm trying to case in with enough time to recoup from their flight. So that's the first thing. Then I'll try to get my strong witnesses up there first. And you're going to be surprised, but one of the things that I sometimes do as a surprise to the defense is I put the defendant on the stand early on my case as an adverse witness. They're not prepared because the defense normally has not sat down and worked with their client at that point on how to testify. They're thinking he's going to testify on the defense side on direct. I've got him up there as a hostile witness so I could lead him. And if I've got 10 or 12 or 15 key questions that I've asked him in depositions that hurt him, I may want to get him up there right away and get that out in front of the jury and take that away from the defense. I played video clips of a defendant in the beginning of my case, and then called him up and asked him a few more questions. And by that time, and then I put a police officer on and maybe a before and after witness, and I've got my whole basic story laid out there so that the jury, by the end of the first day of testimony, really understands where I'm coming from in the case and what it's about. I try not to put too many medical doctors on or experts on one after the other. I try to break them up because that can be boring. And I put my client on usually last. And I try to save that portion of their testimony that's most heart-riveting to the end, and I'll just say no more questions. You have to also look at the time of day. Ask the court, Judge, what's our schedule going to be? What time are we going to start? What time are we going to break? What time is lunch? What time are we coming back? What time do you want to end at the end of the day? The worst thing that could happen happened to me once. I had a doctor on the stand. It was 12 o'clock. I had 2 more questions. The judge says, we're taking a lunch break. I said, but Judge, I have 2 more questions. Counsel, I don't care. We're taking a lunch break. Doctor will see you at 1:30. Doctor said, Judge, I've got surgery. I thought I'd be done before 1 o'clock. I can't be here. Judge looks at me and says, Counsel, doctor's not here, then they haven't had a chance to cross-examine. I'm going to strike his testimony. And I was left scrambling at the last minute, trying to work it out with his doctor to come back and testify, which thankfully we did. And I learned from that point on, you better know that judge's schedule, because some judges will grant you the leeway of an extra 5 or 10 minutes, and others will get up and walk off that bench. And you're just left looking like, oh my God, what do I do now? So know the schedule. And you want to try to end every day on a very strong note. You want those jurors to go home with a good impression in their mind. Because even though they're not supposed to talk about the case, they're not supposed to think about the decisions in the case, they're human. And chances are when they sit at that dinner table and their wife or their husband or their child says, so tell me about your case, they're going to say something about it. And you want them to give positive thoughts about it. You want them to have positive feelings about your case. So try to end on a strong note every day.
How does the scheduling of the witnesses, how is that affected by the technology that those different experts may use? For instance, maybe some people are going to use a lot of illustrations. Some people may use, web conferencing or video. Does that play a role in how you schedule those people to testify?
It plays a role in how I set up the courtroom. If I'm going to be using PowerPoint throughout my trial, I'll get permission from the judge in advance to pre-wire the courtroom, have my monitors set up so that there's no interruption at all. It's got to be seamless. And I work for weeks practicing. I'll get the PowerPoint presentation, put it on my laptop, I'll take it home with me, I'll push the slides, I'll know exactly where everything is. We'll also put scanners on each document and have a notebook. So if I want to pull up a document, that barcode that's on that document will bring up that document immediately. And we work with a system where if I want to highlight a certain portion of a document up on the screen, we could do it on the fly. We could bring it out and make it larger. That's all things that have to be thought of in advance of trial. Medical illustrations, for example, have to be thought of in advance of trial. I have to make sure there are easels in the courtroom, whether they're supplied by the court or whether I have to bring them. I have to make sure that I've got marking pens, highlighters. One of the things that I like to do is use a chalkboard sometimes, and I'll tell you why. Maybe it's my generation and some of the generation after me, but we're used to teachers getting up there and writing on chalkboards. And I find that juries tend to believe things that experts write on chalkboards because they're used to believing teachers and learning that way. So that's a good way, depending on the jurisdiction you're in, of getting some of your important points across. If you're in a jurisdiction with a lot of younger people who don't really are exposed to chalkboards, technology is probably best. You put up the PowerPoint, you put up the laptop, you let the experts play with the technology. You have the Elmo there so that they could draw on the Elmo and it goes up on the screen, and it's the courtroom set up in such a way. All that's important. I had a case recently where I used technology the other side didn't, and the lawyer from the other side is a very good lawyer, kept apologizing to the jury saying he was old school. And after the trial was over and we won, the jury sent them a message saying, you better get with it, old school doesn't work anymore. So you have to know who your panel is, or the jurisdiction that you're in.
So we've taken it up through dealing with the witnesses, preparing the cases, we're in the trial. So I think what might be most important for a lot of the attorneys to know is, how do you handle your opening and closing statements? And what's your purpose of each, and what's your philosophy so that you can reach the goals and win that case?
I don't use notes. I don't believe that if you stand behind a lectern and you read from a note that you're accomplishing your goal. I think you have to speak to the jury as if you're sitting in your living room talking to your friend and telling them about the case. There are slight exceptions to that, and I will normally start out at a closing with a quote, and I'll read the quote. I may read a quote about pain and how it affects one's life. I may read a quote about responsibility when a defendant doesn't want to admit that they were at fault, but I'll do something like that. Well, let's talk in order since you asked that way. Let's talk about opening statement first. Opening statement's my opportunity to go ahead and explain to a jury what my case is all about, and explain to them that a trial is like a puzzle where you're given certain pieces and you, the jury, have to put them together. So when an opening is like the cover of the puzzle, you're going to be shown the complete picture so that when the pieces come in through evidence and testimony and exhibits, you'll be able to understand where they fit, because not everything is sequential in a trial. What I'll try to do is portray the good and the bad about my case. I want to make my client out to be human. Nobody's perfect. In certain jurisdictions, you're allowed to use the golden rule argument. In other jurisdictions, you're not. So you have to know the law of the jurisdiction you're in. I'll try to keep my opening to the point where everything I tell them that I'm going to show in opening, I prove. That's my promise to the jurors, that I will prove by the end of the case A, B, C, D, and E. And please hold me to that. And I should know in advance through rulings by the court if I could get all those pieces of evidence in. I don't want to ever promise a jury something and not be able to bring it out, because then I've lied to the jury, my credibility's shot, my client's credibility is therefore shot. At the end of opening, I will always thank the jury for the attention, their time, and their giving up of their lives to be there, because they're part of an important system. Closing's different. First of all, as I told you, I'll start with a quote usually. I'll tell them, if the judge says this is closing argument, that I'm not there to argue. I'm there to help remind them of what the evidence and the law is in the case. And if my recollection is different than theirs, to use their own recollection. And in many jurisdictions now, jurors are allowed to take notes, and I encourage them to take notes and refer to their notes. But I also use technology. I make sure that the important exhibits or PowerPoint demonstrations that we used are part of my closing discussion, that I replay for them that portion in their mind of that photograph of that knee that's been repaired, of what it looks like, so that they understand what we're talking about. Numbers are important. If there is an economic number, I'll make sure I either have a chart or a board or a chalkboard or a PowerPoint presentation laying out the exact numbers of what the damages are, the past medical bills, the past lost wages, the future medical expenses, the future lost earning capacity, so they understand that. I'll make sure that certain jury instructions are printed or shown to them. Could be about the believability of witnesses. Could be about what the definition of negligence is. I will go over with them again what it means, the burden of proof, the greater weight of the evidence, because many jurors watch criminal cases on television, And I will explain to them, and the court will explain to them, that the burden of proof in a civil case is not above and beyond a reasonable doubt as it is in a criminal case. It's just merely the tipping of the scales of justice. And I'll talk about the lady with the blinders on in the scale of justice and just tipping it 50.1% to 49.9%. And they have to understand that that's my burden, and I have got to carry that burden. I'll talk to them about the shortcomings of my client, that there is no such thing as a perfect rose garden, that if there is a beautiful botanical garden near the courthouse, I may refer to it and say, even if you go to that garden an hour after the gardener crew has finished and you look hard enough, you're going to find a couple of weeds. In anybody's life, you're going to find some weeds. And don't hold that against my client in judging him or her in the overall scheme of what's happened in this case. I will then do something that is absolutely essential, and that's have the verdict form there. And the reason I do that is because it's a little complicated, and I want them to see it, and I want them to see how I think they should fill it out. So when the first question is, was there negligence on the part of and the defendant, which was a legal cause of loss or damage to the plaintiff? And there's a yes and a no. I'll check yes. And I'll go through every question as I give my summation, as we get to that point of my summation. And I'll fill in amounts. And I'll answer questions. And at the end of it, I'll have a verdict form that's filled out for them. And I will explain to them that I don't mean to impose upon their province. This is what I believe the evidence shows. They could award more, they could award less. It's like that famous movie with Paul Newman when the jury came back with a question saying, Your Honor, could we give more than the plaintiff has asked for? That's every plaintiff's lawyer's dream. And when it happens, it's great. But you want to give the jury an idea of what the case is worth in your mind, but give them the knowledge that they can go ahead and award whatever they want. One of the tricks that I use is I bring with me a very long receipt from a supermarket where the bill could be $300-$400, doesn't matter. And I'll explain to a jury that when you add up all the elements of damages, the past medical expenses, the past wages, the future medical expenses, the hospitals in the future, the medications, whether the person needs attendant care, a driver, home modifications, future lost earning capacity. You add all those things up, it's a lot of money. So I'll take out my grocery store list and I'll say, you go to the grocery store and you go shopping and you fill up your shopping cart with all the things you need for your family, the eggs, the bread, the milk, the cookies, the cereal, the toothpaste, the deodorant, the bananas, the fruits, etc. And you start putting it on the checkout line and the lady's rigging it up. And all of a sudden you see the total and you say, oh my God, how did I spend so much money? And you look and you decide, well, what do I give back? What do I take away from this? And you realize you really can't because they're all things your family needs. And it's the same thing in this case. Just because you add up everything that you believe the plaintiff is entitled to and it comes out to a lot of money, don't be afraid to award that amount of money because those are the necessities. And I find that works a lot because all of us go to the supermarket. All of us understand that life is expensive. And it doesn't get any cheaper just because you've been injured. It gets more expensive.
That's some great stuff. So now you've won the case. What's your process? Do you do a review after the case? Do you sit down with your staff? Do you sit down with the clients? Look at what you've done, what you could have done better to prepare for the next case that comes down the line?
Yeah, unfortunately, I postmortem every case. Starting from the minute after the verdict comes back. And I guess they stay with me forever. You could always do better. And I think when you stop trying to do better is when you really should quit being a trial lawyer. Because you could always learn from a trial. You could always learn how to do things better, how to say things better, how to present things better. The world changes, and you've got to be willing to change along with it. There are things that I argue today that I would have never done 30 years ago. And there are things that I could have said 30 years ago I can never say today. I believe that you need to fully explain to your client that maybe just because you won the trial, it's not over. They're going to file a motion for a new trial, a motion for judgment notwithstanding the verdict. They're going to may file an appeal. So all these things have to be explained to your client. You have to explore possibilities of settlement at that point. You have to negotiate liens. lawyers don't understand just by settling a case or getting a verdict, the hard part's still out there. You've got to deal with Medicare or Medicaid. You've got to deal with health insurance companies. You've got to do a whole myriad of things. And you've got to make sure that if this is a case where you've rung the bell, that your record is set to go for appeal. And we hire appellate counsel. And sometimes I'll hire an appellate counsel before I even try a case. So that it's worth to me to pay that percentage more to have somebody sitting in that courtroom who's really thinking about, is Stewart preserving this case for appeal and doing everything he needs to do? I better know the rules of evidence. I better know what I need to do to preserve my client's rights on appeal, or else I'm guilty of malpractice. And a lot of lawyers don't understand that. If a court excludes a piece of evidence or key piece of testimony, I may better make sure that that excluded piece of testimony or evidence has been marked and has been properly put into the record of the court so that the appellate court can consider it. I'll give you a great example. I tried a case last summer. I got a $2.6 million verdict. And during the trial, the defense tried to put on two expert witnesses. One was a pathologist, and one, I'll tell you the truth, he was a general practitioner. And when they called him, I had taken their depositions. When they called them as witnesses, I asked the judge if I could voir dire them outside the presence of the jury because I didn't think that their testimony was credible and would be permitted under the law. The judge sent the jury out. I voir dired both witnesses, and the judge struck both their testimony because she said that there was no legal basis for their testimony. It was too speculative, and gave a bunch of other reasons. Basically, that they didn't pass the Frye test, which we have in Florida, and the Dauber test we have. The defense never put their depositions into evidence. They never asked them any questions. And then on appeal, they try to argue to the appellate court, well, Dr. So-and-so would have said this, and the appellate court said, Dr. So-and-so never testified. You didn't preserve his testimony. We have no idea what Dr. So-and-so was going to say. Therefore, rewrite your brief within 15 days, or your brief is stricken, and you have no appeal. You've got to know the rules. You've got to protect your record because we've all tried cases we should win and we've lost them. We've all tried cases that are probably losses that we've won. So you never know what a jury's going to do. It's a gamble. But you as a professional have to be prepared for everything that could come down the pike.
Well, Stewart, I want to thank you for sharing your strategies for achieving personal injury excellence. It's been a pleasure working with you, and I know that a lot of our listeners out there are going to benefit from your principles, your keys, the systems that you've had and that you've implemented to run a very successful personal injury practice.
Thank you, Rick. It's been a pleasure.
The CLE code for this disc is PIE 9168. For more information on other learning systems, as well as custom in-house training, check us out at www.advantagelegalseminars.com or call us at 305-947-2468.